The Supreme Court just activated an emergency docket entry that could dismantle concealed carry permits in all 50 states. And here's the part that's making Second Amendment lawyers lose their minds. The Department of Justice isn't opposing this. They're actively supporting it. Right now, 28 states have filed amicus briefs on the side pushing to eliminate permits. Not defend them, eliminate them. Permit-dependent states like California, New York, and Illinois are in full panic mode, rewriting statutes in real time, hoping to salvage what's left of their regulatory frameworks. This isn't a normal Supreme Court case working its way through years of appeals. This is an emergency petition that jumped the line, and the speed at which this is moving should tell you everything about how serious the constitutional violation is. If you care about where gun rights are headed in America, you need to understand what's happening right now, because the changes are already starting before the final ruling even drops. Hit subscribe because by the time this video ends, you'll know more about this case than most state legislators trying to react to it. To understand why this emergency petition exploded into a constitutional crisis, you have to see what triggered it in the first place. After the Supreme Court's Bruin decision in 2022 made it clear that May-issue permit systems were unconstitutional, everyone assumed restrictive states would fall in line. They didn't. Instead, they got creative. 6 states, led by Hawaii, California, and New York, didn't eliminate their permit requirements. They restructured them into something arguably worse. They created default ban systems wrapped in the language of property rights. Under these new frameworks, you couldn't carry a firearm anywhere, public or private, unless you had explicit written permission from the property owner, not a sign saying guns welcome, written permission in advance. Hawaii took it furthest. Their statute made it a criminal offense to carry on any private property open to the public unless you possessed documented authorization from the owner. Gas stations, grocery stores, shopping malls, parking lots, all banned by default. The property owner didn't have to post a no-gun sign. They didn't have to say anything. Silence equaled prohibition. Hawaii's legislative record shows this wasn't an accident. Internal emails revealed lawmakers specifically discussed how most businesses would never bother issuing permission, and how that would create a de facto carry ban without explicitly saying so. One legislator wrote, quote, "If we make permission the requirement rather than the exception, we achieve the same result as a ban without calling it a ban." They said it in writing. The lower courts upheld it anyway. The Ninth Circuit ruled 2-1 that Hawaii's system was a reasonable property rights regulation, not a Second Amendment violation. That's when the challengers filed an emergency petition directly to the Supreme Court, arguing that Hawaii had created a permission structure with no historical analog, and that every day it remained in effect was a continuing constitutional violation. The Supreme Court granted certiorari before judgment, an extremely rare move that jumps over the normal appellate process. They put it on an emergency docket. That doesn't happen unless the violation is severe and immediate. But here's where it gets unprecedented. The Department of Justice filed a brief, and instead of defending Hawaii's law or staying neutral, they sided with the challengers. The DOJ's brief used language you almost never see in government filings. They called Hawaii's system pretextual, a legal term that means deliberately deceptive. They said the law wasn't designed to protect property rights. It was engineered to eliminate carry rights through procedural suffocation. The brief pointed out that Hawaii already had trespass laws giving property owners full authority to exclude armed individuals. So why create a default ban requiring written permission? Because the goal was restriction, not protection. The DOJ didn't stop there. They formally requested to participate in oral arguments on the side of the petitioners. In the last 50 years, the federal government has switched sides in a Second Amendment case at the Supreme Court exactly 4 times. This is number 4, and it's the first time they've done it in an emergency posture, signaling they believe the constitutional harm is urgent and ongoing. Then the states started lining up. Within 3 weeks of the Supreme Court granting cert, 28 states filed amicus briefs supporting the challengers. Not 2 or 3, 28. That's more than half the country telling the court that Hawaii's model represents a threat to constitutional consistency nationwide. The briefs weren't gentle. Texas argued that if Hawaii's permission framework is allowed to stand, states could apply the same logic to any constitutional right, requiring written permission to speak in public spaces or written authorization to refuse searches. Florida's brief called it the most brazen post-Bruin attempt to nullify the Second Amendment through regulatory theater. Missouri pointed out that Hawaii's system created a situation where a law-abiding citizen with a state-issued permit could be arrested for carrying in a place they had every legal right to be, simply because they lacked a second permission slip from a private party. These weren't backup filings. These were coordinated legal strikes designed to show the Supreme Court that this isn't a Hawaii problem. It's a national problem. And just when you think this is only about one state's overreach, you need to see how many other states copied the exact same playbook and how fast their systems are about to collapse. Hawaii wasn't acting alone when they built this permission trap. 5 other states watched Bruin come down, analyzed the ruling, and collectively decided to construct nearly identical default ban systems disguised as property rights regulations. California passed Assembly Bill 2571 in September 2022, creating a statewide presumption that all private property prohibits firearms unless explicit permission is documented. New York enacted the Concealed Carry Improvement Act with parallel language. New Jersey followed with Statute 2C 58 4.6. Maryland passed SB 1, and Massachusetts introduced Chapter 135. Between June 2022 and December 2024, these 6 states enacted 52 separate firearm restrictions, all designed around the same core principle. Flip the default. Make carrying the exception, not the rule. Make permission the starting point, not the right. The strategy was deliberate. If they all did it simultaneously, challengers would have to fight state-by-state battles in different circuits, burning resources and time. They bet the Supreme Court wouldn't intervene quickly enough to stop them. That bet just failed catastrophically. The moment the Supreme Court granted emergency review of Hawaii's law, every copycat statute became legally vulnerable, and the impact is already cascading before the final ruling even drops. Right now, 143 active federal lawsuits challenging state carry restrictions sit in district and appellate courts across America. Not 14, not 40, 143. These cases were in holding patterns, waiting for Supreme Court guidance. That guidance is about to arrive like a legal hurricane. Plaintiffs' attorneys are already drafting emergency motions for preliminary injunctions. The moment the Supreme Court issues its ruling, assuming it strikes down Hawaii's framework, every one of those 143 cases will simultaneously demand immediate relief. Courts won't be able to delay. They'll have binding precedent requiring them to enjoin enforcement of similar laws immediately. State attorneys general know this. That's why they're already backing down before the ruling lands. In February 2025, New York Attorney General Letitia James issued an internal memo to county prosecutors advising discretion in charging permit violations under the CCIA. The memo didn't say, stop enforcing the law. It said, use prosecutorial discretion, which is government code for we know this won't survive, and we don't want to be on the hook for wrongful prosecutions. California quietly suspended enforcement of 3 sections of AB 2571 in January 2025. No press release, no official announcement, just internal guidance to law enforcement to pause citations. New Jersey's Attorney General told state police in a December 2024 directive to focus enforcement resources elsewhere unless there's an imminent public safety concern. These are governments in retreat. They're not fighting anymore, they're trying to avoid liability. But if you think the legal collapse is the whole story, you're missing the financial earthquake that's about to flatten state budgets and an entire private industry built on mandatory permits. Permit systems weren't just regulatory structures, they were revenue generators pumping hundreds of millions of dollars into state coffers every year. California collected $52.4 million in concealed carry permit fees in fiscal year 2024. New York brought in $41.2 million. Illinois collected $34.7 million. Hawaii, despite its small population, pulled in $8.3 million. Across all permit-restrictive states, that's over $230 million annually from application fees, renewal charges, background check processing, fingerprinting services, and administrative review costs. That's just direct government revenue. The private sector, built around mandatory training requirements, dwarfs those numbers entirely. Certified carry training courses generated an estimated $740 million in revenue nationwide in 2023. This isn't a few instructors teaching weekend classes, this is a full industrial ecosystem. Companies printing state-approved certificates, shooting ranges built specifically for mandated courses, insurance providers covering training liability, software firms selling applicant tracking systems to state agencies, law firms specializing in permit denials and appeals. When permits become optional instead of mandatory, that entire economic structure collapses overnight. States are already feeling the financial pain. Hawaii's Firearms Permit Division employed 51 staff members in 2023. By March 2025, that number dropped to 22 because permit applications fell 81% as applicants waited to see if the requirement would survive the Supreme Court. New York has issued over $7.9 million in refunds to 16,400 applicants for training courses that courts blocked from being enforced. California stopped collecting its $100 permit issuance fee in January 2025 after a district court issued a preliminary injunction, costing the state $1.4 million per month in lost revenue. New Jersey's Office of Management and Budget projects that eliminating carry permits would create a $47 million annual budget shortfall with no identified replacement revenue source. Illinois Treasury estimates $38 million. These aren't abstract projections. These are real dollars funding salaries, office space, IT infrastructure, and personnel. The private training industry is in freefall. Between October 2024 and February 2025, 4 of the largest concealed carry training companies filed for bankruptcy protection. All four cited the same reason in their filings. Anticipated regulatory changes, eliminating mandatory training requirements. One company, Certified Defense Training LLC, operated 47 locations across 6 states. They employed 340 instructors. They're gone. Another, Safe Carry Education Group, provided training to 68,000 students in 2023. They shut down entirely in January 2025. The CEO's statement said, "We built a business around state mandates. When the mandates disappear, so does the business model." But the financial chaos is only part of the crisis unfolding right now. Law enforcement is caught in an impossible position, and what they're doing about it should concern everyone. Sheriffs, police chiefs, and prosecutors are staring at laws they're supposed to enforce that might be unconstitutional within weeks, and they're making calculated decisions to protect themselves. In February 2025, 23 sheriffs across California issued a joint public statement declaring they would no longer proactively check concealed carry permits during traffic stops or field contacts unless the individual was actively committing another crime. Their statement said, "We cannot in good conscience enforce a regulatory requirement that the nation's highest court may imminently strike down as unconstitutional. Doing so exposes our departments and our officers to civil liability we cannot justify." That's 23 elected law enforcement officials publicly refusing to enforce state law. Not because they're rogue actors, because they're protecting their departments from federal civil rights lawsuits. They're not alone. A January 2025 survey of 410 police chiefs conducted by the International Association of Chiefs of Police found that 67% had issued internal guidance directing officers to use discretion on permit violations. Translation: look the other way unless there's a compelling public safety justification. Prosecutors made the same risk calculation. Between July 2024 and February 2025, district attorneys in 18 counties across permit-restrictive states dismissed 2,140 pending criminal charges related solely to permit violations. Not charges against prohibited persons, not charges tied to other criminal conduct. Just permit paperwork violations for otherwise law-abiding citizens. Why drop cases? Because if the Supreme Court rules against Hawaii, every one of those convictions becomes a potential Section 1983 civil rights lawsuit. Defendants will sue for wrongful prosecution under an unconstitutional statute. They'll demand attorney fees. They'll seek damages. And some will win substantial settlements. No district attorney wants to write 6-figure checks defending prosecutions under a law the Supreme Court declared unconstitutional. Gun control organizations went into crisis mode. Everytown for Gun Safety held 4 emergency strategy sessions in January 2025. Leaked internal communications obtained through FOIA requests show leadership discussing post-permit regulatory frameworks and alternative restriction strategies. That's not the language of confidence. That's the language of defeat management. Giffords Law Center redirected $5.1 million from state lobbying efforts to federal litigation support in December 2024. They're not funding campaigns to pass new laws. They're funding lawyers to limit how badly they lose existing ones. The Brady campaign issued a public statement calling the Supreme Court's emergency docket decision judicial activism and urging state legislatures to prepare contingency regulations. Contingency regulations. They're already planning for life after permits. This isn't just a legal battle anymore. This is a fundamental question about how constitutional rights function in America. And the answer the Supreme Court gives will reshape the relationship between citizens and state power for generations. The core question the Supreme Court is deciding isn't really about guns. It's about whether your constitutional rights start with you or with the government. If the answer is you, then every state that built regulatory frameworks around permission first, right second, loses its entire foundation. For decades, states argued that gun rights were special, different, that requiring government permission to carry was reasonable in ways it would never be for speech or religion or protection from unreasonable searches. The Supreme Court rejected that argument in Bruin. They said the Second Amendment isn't a second-class right. It gets the same rigorous protection as the First Amendment and the Fourth Amendment. But Hawaii and the copycat states didn't listen. They kept treating gun ownership as a privilege the government grants, not a right the government protects. Hawaii took that logic to its extreme conclusion. They built a system where you have no right to carry anywhere, public or private, unless you obtain permission from 2 separate sources. First, the state issues you a permit. Then, every single property owner must grant you individualized written authorization. 1 permission slip isn't enough. You need 2. Imagine applying that framework to other rights. Imagine needing a government permit to protest and then needing written permission from every building owner along your march route. Imagine needing state approval to practice your religion and then needing documented authorization from every property owner before entering to worship. Imagine needing permission to refuse a police search of your car and then needing a second permission slip from your local government. It's absurd. And that's the point. Rights don't work that way. The historical test that Bruin established makes this even clearer. Legal historians combed through centuries of American firearms regulations looking for historical analogs to Hawaii's permission requirement. They found 0 examples. None. States regulated where you could carry and how you could carry. They prohibited certain dangerous individuals from carrying, but they never required blanket government permission for law-abiding citizens to exercise the right to bear arms. The closest historical analog Hawaii could find was an 1871 Tennessee law requiring pistol permits for concealed carry. Tennessee's own Supreme Court struck it down in 1872 as unconstitutional, saying the right to bear arms cannot be conditioned on obtaining government approval. That was 153 years ago. Hawaii tried arguing that property rights created an exception to the Second Amendment. Property owners, they claimed, have the right to exclude armed individuals, so requiring their permission isn't a Second Amendment violation, it's a property rights protection. The DOJ's brief destroyed that argument. Yes, property owners have exclusion rights. Those rights are protected through trespass law. If an owner doesn't want armed individuals on their property, they post a sign or verbally communicate that restriction. If someone violates it, they're trespassing. That system respects both property rights and the Second Amendment. Hawaii's system doesn't. Hawaii's system requires pre-clearance permission, turning the right to carry into a privilege that disappears unless 2 separate parties grant approval. That's not protecting property rights. That's eliminating the Second Amendment through procedural strangulation. This is the moment of truth. The Supreme Court isn't just reviewing a quirky Hawaii regulation. They're deciding who holds default power in America, the citizen or the state. If the court rules that rights begin with the citizen and restrictions require historical justification, then every permission-based regulatory framework collapses. Not just for guns, for everything. Because if you can't require permission to exercise the Second Amendment, you can't require permission to exercise any constitutional right. Once the Supreme Court answers that question, everything else falls into place. But the implementation won't be clean. It'll unfold state by state, court by court, over the next 2 years. And what that looks like is something most people haven't thought through yet. What does America actually look like if permit requirements disappear? We already know. 29 states currently allow permitless carry right now. Between 2010 and 2024, 21 states transitioned from permit required to constitutional carry. Crime didn't explode, society didn't collapse. FBI uniform crime reports show that violent crime in constitutional carry states decreased an average of 7.4% in the 3 years following implementation, compared to 2.3% in permit-required states during the same period. Vermont never required a permit. Not in 2024, not in 1924, not ever. Vermont has never had a concealed carry permit requirement in its entire history. It's also one of the safest states in America with one of the lowest gun homicide rates in the nation. Maine adopted constitutional carry in 2015. 10 years later, their gun homicide rate is 1.2 per 100,000, lower than it was before permitless carry. New Hampshire went permitless in 2017, South Dakota in 2019, Iowa in 2021. Neither saw increases in gun violence. What permitless carry actually does is eliminate bureaucratic gatekeeping for law-abiding citizens while doing absolutely nothing to stop criminals who weren't obtaining permits anyway. Criminals don't apply for permits. They never did. Permit systems only burdened people who follow the law. Implementation will vary by state. Some will transition to fully permitless carry. Others will keep permits as optional for interstate reciprocity purposes. Training will shift from government-mandated requirements to voluntary private education, just like we don't require civics courses before voting or journalism degrees before publishing. The Supreme Court's ruling won't create one uniform national system. It'll establish a constitutional baseline that every state must meet while leaving room for reasonable variation. The practical rollout will take 18 to 36 months as states rewrite statutes, courts resolve pending cases, and law enforcement adapts procedures. Some jurisdictions will move immediately because the legal writing is already on the wall. Others will resist until lawsuits force compliance, but the direction is set. America is moving toward a system where the right to carry doesn't begin at a permit office, doesn't depend on bureaucratic approval, doesn't require paying fees to exercise a constitutional right, and doesn't vanish the moment you step onto private property. It begins with the citizen. The Supreme Court is about to make that official, and every state that built the opposite system is about to learn a very expensive lesson about what happens when you treat constitutional rights like government-granted privileges. So that's where we stand right now, a Supreme Court on the verge of redefining the scope of gun rights nationwide. states scrambling to rewrite laws they know won't survive, a permit system running out of time and out of legal justification, law enforcement backing away from enforcement, an entire industry collapsing, and a constitutional question that will echo far beyond firearms into how we understand the relationship between citizens and state power. If you want to stay ahead of this story as it develops and understand exactly how the ruling will affect your state, hit that subscribe button and turn on notifications right now, because when this decision drops, the changes will happen fast, and you'll want to know what's coming before it arrives.